both Johns are here, but John Green is here. And she's also acted for clients in a number of multiple adjudications under the Act. She worked at Kensington Swan from 2000 to 2016 and was a partner and co-leader of the Kensington Swan construction law team from 2007 to 2016. And then 2016, Mary saw the light. And she decided to start practicing as an independent barrister with a focus on adjudication and providing strategic advice. Next to Mary's right, to my left, Graeme Christie. Graeme is tonight filling the lawyer role on the panel, although he is also an adjudicator. Graeme is a construction lawyer with over 30 years experience in construction law. Graeme has been involved in many major construction projects, both on and offshore, and is well known in the construction industry as a leading practitioner in the field. When he is not acting for clients in adjudications, Graeme can be found resolving construction disputes in other ways. Anyway, negotiated settlements, mediation, arbitration, and litigation. He has also acted as an arbitrator on the ICC International Construction Disputes sitting in London, and as an adjudicator, as I said, in construction contracts adjudications under the Act here in New Zealand. To my immediate left, Tom Horder. Tom is a major projects construction lawyer with experience acting for principals, consultants, subcontractors, suppliers, and head contractors across a variety of horizontal and vertical infrastructure projects. Tom started his career as a litigation lawyer and has been involved in a wide variety of construction disputes, from adjudications large and small to major litigation and arbitration. So while Tom is filling the client role tonight, having acted, for the past 7 years as legal manager for CPV contractors in New Zealand, he also has the experience of counsel. So my role is sort of a Graham Norton-esque role I find myself in. I've got my famous guests, minus a couch. We've got chairs instead. There's no red chair for any of you to be bucketed out of. And we do have beverages. So as we said before, please partake and stay afterwards for a bit of a celebration. And we've got our stellar audience, which I'm hoping will help contribute to the success of the panel tonight. We have had only preliminary discussion about how this is all going to go, but the panelists and myself thought that it would be good if the audience is able to participate throughout by asking questions that will, we hope, promote more thought-provoking discussion and a lively discussion. So while I've got a number of questions that I'm keen to get into with our panel, I'll encourage you to raise your hand if you've got a question, and we can send over the roving mic so that the panel can hear you and can ask your question throughout. We've also got people joining us by live stream, as Naseem said, and they'll be able to ask questions online. And Mark Gillard to my right, a special counsel in our construction team, is going to moderate the questions online and be able to put those through to the panel as and when.
Someone's just said that, can't you just ask people to break in?
Okay, everybody on live stream, have you heard the last 10 minutes? How do you know? Pardon?
Might be they didn't join in.
Is there?
Someone said that is coming through, so it must just be.
Okay, so you need to join via the live stream link, and then you'll hear my annoying voice soon.
No, we're a couple of people saying
they can hear. Okay, so I think we'll kick on from there, and I guess I would like to start with the title of the panel discussion tonight. What does good adjudication look like? And perhaps that is a bit presumptuous of us in that it assumes that adjudication is an appropriate forum for resolution of disputes in the first place. So first question I'd like to pose of the panel is whether you think there are some disputes which adjudication is simply not a good fit for, and which disputes and why. And this is a bit of a free-for-all, so I'm looking to you guys to start off.
Okay, I think I'll start because the lawyer is probably the first one that's going to have to face that. A client's come in, the client wants to go and smack someone on the nose just before Christmas, and that's often a silly approach because it fails to appreciate that the other side's going to get a sensible period of time anyway. So this whole sort of ambush philosophy has disappeared to a large extent. And so that, you know, what the lawyer should be doing is the lawyer should be saying, well, look, sometimes the long way around is the quickest way home. Maybe this is a dispute that is better to go straight to arbitration than get bogged down in an adjudication. I think credibility issues can be a real problem in adjudication because it's only ever done on the papers. And so sometimes, you know, the critical question is whether you can really, I mean, a good example of that is probably the vector tunnel dispute. That was a multi-million-dollar dispute, and the allegation was really all about fraud. And really what they should have done is they needed to get the key guy in the witness box and cross-examine him. And it's too easy to fluff away on the documents if you've got critical credibility issues like that. So probably not appropriate. What about the thing being too complicated? Sometimes it's too complicated. I had one as adjudicator, 77 defects in the time frames that you got. So, you know, it's just, it doesn't work necessarily all the time. And there is a need to filter what's going to work and what isn't going to work. And often as the lawyer, what you'll be doing is saying, that one just seems a bit, you know, like it's mate, you think you're right, but it's going to be hard to get the message across. But actually, the real issue here is the engineer doesn't understand concurrency. That's what we've got to do. We've got to put in one claim, extension of time, and we're going to destroy his philosophy on concurrency because it's totally wrong, rather than complicating it with a whole lot of other add-ons. Having said that, sometimes it helps to have something in there that you know the adjudicator is going to throw away and you're not going to win on. So sometimes there is something useful, including something like that in there.
Yeah. Anyone else on the panel want to add your bit?
I guess the major form of dispute resolution and construction actually happens between the parties before any. You know, that's where probably 80% of disputes are resolved. So I guess once you get to the lawyer stage, then you're in a different ballpark. But I'm a champion for adjudication. I think that from what I've seen of arbitration decisions, you know, sure, there are times and things you're talking about, Graeme, but I think you actually get to the truth of things in adjudication pretty. You know, there's not much that you can hide in adjudication. You think you can, but you can't really. And so my feeling is that adjudication is an appropriate forum for most disputes, construction disputes.
What do you do, Mary, with that question about credibility? Because I find that's one where I've struggled as a counsel and thinking, you know, we've got this opportunity to put in submissions and evidence, but really the sort of the credibility issue that Graeme spoke to, and how you test that as an adjudicator when you're not typically not calling conferences and doing any cross-examination on the evidence.
I can only speak from my experience, but it's pretty easy to tell, I reckon. Like, people think that you can hide things in adjudication, you can't. And people, when they write a statement, they reveal their position or they reveal what they're trying to hide more than what they're trying to say sometimes. And I think that, you know, sure, there will be times, sure, that arbitration and cross-examination is appropriate, but don't get sucked into the lawyer, you know, the litigation model, because it is way more expensive. And in the end, adjudication is an appropriate method of resolution. Maybe it's quick and dirty and all the rest of it, but in the end, I think you will find the arbitration decision won't be that much different.
So that was a thought you had, Tom, when we talked about this. You as a client had in terms of your advice to your people or others, had a ratio of what you thought you would achieve in an adjudication compared to an arbitration, didn't you?
Yeah, I think there are natural limits. I mean, I agree. I don't think there's any disagreement really that it's a very efficient means of resolving disputes as compared to any other option. But certainly my experience has been that you do run into some very practical limits at times around scale and complexity, particularly in the context of expert evidence, where you might have, you know, one adjudicator trying to deal with a huge volume of information, and in the context of an arbitral court trial, the decision maker has so much of an opportunity to eyeball them, to test credibility, as you say, to unpack and distill, whereas when you've just received hundreds of pages of nonsense in submissions and you're trying to sift through and find the grain of truth and credibility in that, I think that's hard for anyone to do effectively. And so my sense is that it's generally a very effective and efficient means of resolving most disputes, but certainly my sense is that where your claim is heavily reliant on really complex expert evidence, I think the risk of not getting your point across is much higher than when you've got when there's the traditional ability to test evidence in a trial. So yeah, there is a limit there, but it's only really applicable to a fairly narrow class of dispute overall, I would say.
Yeah, and so you would say what, if you were looking at it on a ratio basis, the adjudication probably gives you the right answer about 80%, 70%, 80% of the time,
yeah,
for a lot less cost. I mean, the other thing that shouldn't be overlooked is that adjudication is just one of the things in the litigation arsenal, right? And just because you embark upon adjudication as being the appropriate thing to do at that point in time, doesn't mean to say that something else can't happen. Doesn't mean to say that once you have exchanged all the papers and are waiting on the decision, that you still can't settle it. And indeed, I've had one with Shanti where we've done exactly that. And I think I've had one with Tom's business as well, where we did that. After all the papers are in, the arguments are all well known, you can still settle it, and there's a value in that. Not for the adjudicator, Mary, to miss out on the fee, but
they've done some work. There's still an invoice to come. But yeah, I guess that, and then if you realize too, potentially that there are those issues of complexity or those credibility issues or something that in the case has risk with it that even potentially motivates.
well, sometimes adjudication comes about because
there's
there's such a bad breakdown in the relationship. It's got to the point where they need a decision maker and they've lost control of it. But so, another factor as to why you go and do a deal, even after you've exchanged all the papers in the adjudication, is the commercial relationship. You want to restore the commercial relationship. You just think on this particular item, I've been treated unfairly and I'm bringing my claim, but that doesn't mean to say that I don't understand your arguments and your position and I'm not willing to compromise to find a solution and go forward.
Yeah, I think that's right. I think there are some other factors that might influence the decision that we perhaps haven't touched on. One of them is just the question of precedent. Like for some larger players, particularly if you're like a Crown principal or a large private sector principal or even a large contractor, one of the issues we have, which we'll probably get to tonight, is the issue of case law. And if you've got an issue that's coming up over and over again, and you want to know what the answer is, sometimes it's a good idea to actually do that in a public forum. Now, not many people want to fund the development of the common law, obviously, but that is a factor if you've got a really big grunty issue that you want clarity on. And I think the only other thing I'll mention is that there is a perception that the adjudication system is kind of pro-claimant somewhat. The way people kind of talk about the tenancy tribunal, but in a totally different kind of nature. There is a sense that it was set up, the policy reason was to make cash flow, and there is this incentive to look after the little guy, if you like. So if you are Goliath in a David and Goliath dispute, one of the things you think about before you get into an adjudication kind of scenario is how does the relative power of the parties play in in the nature of the dispute. So, that's something that definitely finds voice from time to time.
Yeah, and as a lawyer, one of the things you can do there is you ghost it. The client does all the you're not seen in any visibility at all, because what you're trying to portray is poor little
Mm.
innocent little client that's being
Yeah.
stomped. But Mary, do you agree though that that sometimes the adjudicators bends over backwards to look after the little guy, or is it simply that you have the safety valve from the adjudication that if in fact you're wrong, they'll get it back anyway?
There's two questions there. Do I look after the little guy? Well, I acknowledge that the Act started, grew out of a need for cash flow and a perception that there were power relationships that needed to be rebalanced. So, and I don't think that's changed at all. So, adjudication has been a means by which the little guy can take a case without having to be, debt driven for years because they can't afford going further. So I think there's quite a few strands to that.
Yeah, and there's also sort of Tom's point about sort of wanting to, if you're in the shoes of a Crown entity or public authority and wanting to know what the outcome might be if you roll the dice to adjudication, there's sometimes not that much choice really, because you've got our standard form contracts, which are arbitration as a final means of dispute resolution or adjudication under the CCA, and you don't have that opportunity to sort of have that precedent to look to. But yeah, I think we might come on to that shortly, and all sort of interesting comments by each of the panel members. Yeah, I do have a question sort of going back to basics, and there's a lot of lawyers in the room, I think, too. And it's a question that doesn't really, it must come up because we've sort of briefly talked about it with the panel, and you don't know what question's coming, but the question about how you pick a lawyer suited for an adjudication versus another proceeding versus an arbitration or a piece of litigation. And this one is sort of, I think, Tom, to you in the first instance to comment on from a client perspective about, when you're looking, you're either bringing an adjudication or you're going to be imminently defending an adjudication claim. What sort of makes the right lawyer for adjudication versus some of these other processes, if indeed they're available to you?
Yeah, well, I think of adjudication as kind of, Pareto dispute resolution, essentially 80-20 dispute resolution. So you're looking for people who can who can live with something that's 80% good, not 99% good. And if you're only doing really large litigation all the time in your practice, my experience has been it's often quite hard to calibrate to the adjudication environment, just because you're used to a certain mode and intensity, and it's hard to translate that often into a 80-20 rough and ready kind of context. So I think what I really look for in adjudication is that efficiency and awareness of living with the imperfection, because we expect when it depends on the size and scale of the dispute, but often in adjudication you're talking about something that you can't go and spend millions of dollars on, even though it might be a bit complex. You've just got to find a way to get to that 80% good enough point, and having somebody who knows how to do that is my number one thing.
Yeah, and I guess is it a factor as well of looking at somebody who can be a bit agile, because obviously we've got the extra right of reply and rejoinder following on from the adjudication response, but it's still a fast process when you compare it to the other processes. I don't know if it sort of would seem to me to come into it in terms of somebody being able to work quickly and be prepared to accept perhaps not 100% of the T's, but everything, 80-20, or the rule that you've got pretty much everything there and you've got the key points across.
And keep it simple as well. Some of the biggest stuff ups I've been a party to have just been not enough distillation. And then I think the poor decision makers sitting there trying to figure out what of our 14 alternative arguments we're actually trying to argue, and it's like you've taken an exhaustive approach, but have you actually been very convincing? I feel like we've walked into that trap sometimes.
Yeah. So this sort of leads on to something that does seem to get a lot of airtime or focus, in my experience anyway, at the outset of an adjudication proceeding. And that's about how the parties or one party might influence or go about selecting an adjudicator that they consider as an appropriate adjudicator for the particular dispute. And Graeme, I notionally had your name down for this
Yeah,
one.
I think people like John Walton are very strong on you should always try and agree an adjudicator, and I agree with that, because then you know who you're getting rather than some random process. I always find it surprising that both in adjudication and arbitration, people put forward one name. It's never going to work. Your client's always going to go, but it must be their mailman or there's someone they know them somehow. So you've got to put up a range of names, and competent, capable parties should be able to agree on an adjudicator who's got experience and possibly got experience in the matter that, well, the fundamental issue that it's about. So if it's about delay, there's going to be an analysis of delay experts. Then really you want somebody who knows about the protocol, knows about retrospective analysis, rather than has to go away and work it all out and try and understand what it's about.
I feel like the client conversation is often much less sophisticated than you probably give clients credit for, actually, Graeme. My experience, 90% of the time, what happens is it's like, okay, we've got an adjudication. Who should we go for? And there's this mythical world of two buckets whereby it's like, well, are they a black letter lawyer who's going to enforce the contract, even though you might be Goliath? Or are they a kind of a pragmatic, principle-driven decision maker? I feel like I've heard 15,000 different versions of that conversation, like which bucket. And then depending on your particular claim, you make a choice as to which bucket you want to go into. That's usually how it goes. And then, but I think one of the real successes of adjudication has been the way it's incentivized adjudicators to trade on their impartiality and their neutrality. Because the moment, of course, you're perceived as being contractor friendly or principal friendly, people aren't going to want to agree to work, for you to be their decision maker if they don't trust that you've got that impartiality. So I think that's been very successful in New Zealand. Like, there's generally relatively high levels of trust in that, which I would love to see imitated in the context of independent certifiers, if we can just throw that grenade into the room. But yeah, I think that perception about what style generally are you looking for, and then the other question that's coming up more and more is diversity, actually. Because it used to be, hi, we need an adjudicator. Okay, which middle-aged white man named John or Chris would you like? No offense to the Johns and the Chris's, but it's but I think the diversity of options has grown over time. For the good.
Yeah,
I think another feature to be conscious of, if you're not, if you're going to Amens generally is going to point from its own panel. Right, so that's the first question you have to ask yourself: who's on the panel that we're likely to get? Because if, in fact, we're debating 2 or 3 people who aren't on the panel, then they're never going to get appointed by Amens. You're better off to agree them and get the choice yourself. I think you're right, Tom. People do talk about this, and it's probably a lawyer fixation about black letter lawyer or not. But really, the analysis should be, well, who's going to give the right result? It shouldn't really get skewed by what kind of lawyer the adjudicator is.
Yeah, I think that's right. I think that's something else that you said about sort of that, should you agree an adjudicator, is also sort of the fundamental question, and there's lots of reasons, I think, for doing that. One of them is compelling, in my view anyway, is that the point that if you've got 2 parties who are adversarial, obviously, at the outset, because they've gotten to the point of considering an adjudication claim and being at the back end of the gun on the defense side or the respondent side, agreeing an adjudicator at least potentially means that at the end of the day, you both agreed on who's the decision maker, and you've got a little bit more sort of skin in the game and ability to accept the outcome at the end of the day. Sort of the right, we've agreed who's going to take this, as opposed to an appointment, which is unilateral.
No client wants potluck. Like it's, I mean, I don't know how many I've done of these, maybe 30. I think maybe on 2 occasions we actually ended up in nomination, because it's for a client, it's a sense of loss of control. You don't know who you're going to get, and so I think most of the time you manage to agree someone because people get the ability to exert some control over it.
Yeah, and when the one out the back window, there's a huge adjudication and all the criticisms of the adjudicator that the other side brought when they lost, they nominated him. They put him forward till we just agreed. So, you know, that's one of the most powerful things you can have. The starting point of a judicial review of adjudications, they know what they're talking about, but hang on, it was your choice. So it's really helpful, I think, to get to the point where there is agreement rather than leave it to the random potluck.
I don't think the BDT, who I mostly get appointments from, is potluck. I think that my experience of them is they do think very carefully about the type of the dispute and the appropriate appointee. So I don't see that that's potluck at all.
No, but it's potluck from the client's perspective.
They didn't agree, but yeah.
Yeah, well, I wonder if that's well communicated enough, actually, like the transparency around how that selection happens across the nominating bodies, because it's probably a bit of a black box to the client.
Well, it's probably to us too, really, as adjudicators. We don't. But I have pretty, you know, a lot of confidence in the BDT on how they appoint adjudicators. I don't. So.
Yeah. No, I don't think we're suggesting that the potluck is because the way the appointment occurs. The potluck is from the perspective of the client who's suddenly given someone maybe perfectly appropriate, but they had no say in it. They had no feel in it.
It's a sense of control. Yeah. But I think I agree with you that I think the overall trust in appointments is relatively good. It's not like we've got like in some jurisdictions, you've got quite a wide range of, I think, capability levels when it comes to adjudication. I don't think we really have that here. You know, you can kind of come out of university, work for about 3 years and become an adjudicator in some places, but it's not like that here. So I think there is high trust, but I think you could probably improve that through transparency and people understanding how that selection happens so that people can trust in the process.
Yeah, I think that's all sort of really good points about sort of that. Yeah, good to agree, but also good to understand when there is an appointment, how that's being done. If there's more transparency incorporated into that, I think that would be a good thing. Just moving on to slightly different topic and just looking at the preliminary matters or gateway questions and what happens after you've got your lawyer and you've got your adjudicator and you've got your expert. I'm just going to skip over because I think we'll come back to expert evidence shortly. Is the topic of what matters are there that could reasonably or should reasonably be agreed between the parties and their counsel at the outset. And I'm thinking the matters that commonly come up, like jurisdiction, timetable matters, security for the adjudicator's cost, if that is something that you can decide, and whether there's a potential for agreeing the scope of matters in dispute or not. I'm just keen to hear the panel's thoughts about what you consider are appropriate matters that you should, generally speaking, or in the right case potentially, try and agree at the outset with the other side to facilitate the process.
I think you should always be trying to agree the timetable. I think you've got rocks in your head if you leave the timetable to be determined by an argument. The best thing you can do in terms of agreeing timetable is agree to extend the reply period beyond 5 days and the rejoinder beyond 2 working days. If you've got a big adjudication, why settle yourself with that nonsense? So even if you can't agree on the time for the reply, you can still agree on that. You just ask the adjudicator, only decide the time for the reply. And, you know, to me, it's just a crazy argument to have a whole lot of debate about the adjudicator is going to give them a reasonable and fair time anyway. So you should be able to agree on that. And you get control, again, as Tom said, you get control. You know when it's going to be done, what days it's going to, you get your experts lined up, you know all of that. Otherwise, you get foisted with something that may not suit you and your client as well. And, you know, really, are you going to achieve too much in fighting the time?
Yeah.
Aren't they going to get it?
Yeah.
What do you think, Mary? You're going to give the time?
I was going to say, from counsel's perspective, I kind of agree with that, but I'm interested in Mary as an adjudicator's view.
Depends on how much time they ask for. You know, people who aren't experienced in adjudication ask for so much more time for the response, for example, than those who are used to it. And that's part of your point, Tom, that you know, learning how to be efficient in the process is really important. But I agree, it is so much better if people agree the time for the response. As for the reply and the rejoinder, you know, I do have an issue that section 42 doesn't actually, you know, I'd probably go along with what the parties agree, but there is an issue that section 42 of the Act doesn't actually allow to extend those timeframes. And there's good reasons for that you want the reply and the rejoinder to be brief and succinct and short. You know, you don't want to just extend, have another whole round or great big round of submissions and statements and all the rest of it. So I think the response is where most exceptional time comes.
Timetable is an interesting one because I think it shows in some ways how far practice has moved from the original legislation. You know, like how many adjudications, I wonder, stick with 5 days for a response. I would wager very few.
Yet it's probably the norm in Australia.
Well,
Yeah,
it's certainly a lot shorter. In fact, I was talking to
Yes.
that's right. Although you can,
That goes back to our first question about scope.
although you can pretty much put anything in adjudication over there that you could hear. You just put in a payment claim, and then you know. So it's a formalistic distinction, I think. But timeframes are shorter there. I was talking to an adjudicator friend over there today and asked him this question actually. You know, how do you, because he's done stuff over here as well, and he was saying, yeah, he finds them quite long here, and there definitely is from a client perspective this Parkinson's law issue. You're familiar with Parkinson's law? You know, it's like you basically fill the work to the amount of time you have. I've definitely noticed a relationship in that regard in terms of the costs we incur in disputes. Is the longer the timetable, the more expensive it often becomes. Because the time you have, you spend optimizing and polishing, and so there's a real balance to be struck to force the parties to get to the heart of things, and I think the timetable is the primary tool to do that. And this is one of those things I wonder if next time they do some changes to the Act, if it could, you know, you might want to, we could reflect the realistic range of how timetabling is actually happening. Because, you know, it's never 5 days. It's my experience, somewhere between 4 and 8 weeks, depending on how.
I was going to say,
yeah,
you know,
that's right.
I would have said 6 weeks was about the norm.
Yes,
for most
the
of the
average.
things.
I reckon that is.
So it's, yeah.
Okay. What about jurisdiction? I'm just interested in the panel's view because it will, I think, come from different perspectives about taking a point as to jurisdiction at the outset as a preliminary challenge versus having jurisdiction be a challenge in the response to a claim, you know, probably strategic reasons, but also potentially end of adjudication claims. I mean, I just want to hear from any of you, whoever wants to go first, maybe Mary, in terms of an adjudicator's perspective.
Jurisdictional issues come up all the time, and it really is depending on the circumstances of the case, whether you do a preliminary ruling on it, and because that could be the end of the whole thing, or whether you do it as part of your determination. And you can sort of get a bit of a sense of it, like, and it does depend on the time frame. Like some people put a jurisdictional issue in even before the claim is filed or quite early in the process. I've had jurisdictional issues raised almost the day before the response is due. So in that case, I'm like, no, I'm not going to rule on it in a preliminary way at all. And I think jurisdictional issues, you asked before whether it's something the parties could agree. Sure, I mean, you know, that'd be great, but by then they're fighting, you know, and so they're like, they're not going to agree on that if they're already fighting.
Right.
So the difficulty often with the jurisdiction or an argument that something's not in reply is, as an adjudicator, how do you get on top of all of that at that point in time, as opposed to, as you say, deal with it in your determination?
How do you get on top of the jurisdiction?
Yeah, how do you, if a jurisdiction point's raised or someone raises an argument that this is not at the point in time of the reply,
Yeah.
before the rejoinder, this is not in reply. I mean, how's the adjudicator realistically
Well,
going to
that's
get on
talking-
top of it all?
That's more of an
Oh,
yeah, I
evidentiary
was
point, though.
Yeah,
But-
it's like more,
Yeah.
more procedural.
So we're talking about here,
compliance,
just to be clear, we're talking about like scope of
Jurisdiction.
dispute.
Yeah,
pretty
yeah.
much, like, is this
whether or not it's
dispute
in or out. If it's a question, like you said, Graeme, before about, there's a fraud case, well, we're not in adjudication really, because we've got the construction contract set for and 4 corners of a construction contract for an adjudicator to decide. So question about jurisdiction of whether or not it's actually a claim that the adjudicator has the ability to decide, and whether that is something that should be always or sometimes dealt with up front at the outset, or whether that should be part of the substantive determination
Yeah, I suppose
after all
what
the
I'm
evidence
saying is
and
the difficulty
submissions have
for
gone
an
in.
adjudicator to deal with it early on, before they really know what the whole
Yeah,
thing's
that
about.
is true. That is true, because and actually getting people to respond to the jurisdictional issue in the reply and the rejoinder often narrows the issue anyway. Like you actually start to get what the real issue is about. So,
Yeah, it's tricky because I think it depends on who you are in the dispute from a client perspective. If you're the defendant, well, maybe if you're both, I think stepping outside of which hat you're wearing, it's inefficient to go through a whole claim process and then find out that the adjudicator didn't have jurisdiction, because then you have to run the dispute again, which sucks, buying the same thing twice. So I think objectively, if it can be dealt with earlier on, it means less transaction costs, which is
That's right.
generally good. There are technical reasons why a party might not want that, because they're trying to create leverage for a deal or something. But I think objectively, earlier the better to resolve that, if you can, so that you can avoid the wastage risk.
Yeah.
Yeah.
How often do jurisdictional things get upheld? I mean, it's not the bulk of the claims, and even judicial reviews. While there have been judicial reviews over jurisdiction, they're not that common.
No.
So a lot of jurisdictional issues are raised, things like the payment claim doesn't accord with the contract. Well, that's not a jurisdictional issue, but those are kind of like, you have these random things thrown out, like compared to quite substantive issues. For me, it's about when in the process it's raised. If I can do it early, I will, because that does save costs, obviously. And but also, if it gets to my determination, I will always decide jurisdiction first.
Yeah.
And and then that could be over. I don't have to go any further with the determination. So that's how I approach it.
I think the classic one in New Zealand seems to be, is the matter in dispute or not? Because what happens is there's a stoush around the payment claim or whatever, and then adjudication commences, and then the claim might evolve somewhat, and then you find yourself looking at the claim and going, oh, this isn't actually the same claim that was put in the payment claim, so is this thing actually disputed or not? And it's just kind of a vague boundary problem. That's what I've seen before in jurisdictional issues. It's just scope. What's the scope of the dispute, and are we straying beyond that in the way that the dispute is defined in the notice, or in the claim, or in the original payment claim? Because
but you've got to let people have their arguments. They're always going to raise new arguments in the claim and in the response, and so they'll think up something. Oh, here's a new argument. I thought that one. I'll bring that one up. I mean, that's the flexibility. That's the beauty of adjudication. Is it actually gives people those opportunities. And tough shit, you didn't have that argument before, responded, but now you do. Well, deal with it. You're going to have it in the next one if you go to arbitration. I just think, get over it. Like there's far too many jurisdictional issues raised, and most of them are rubbish. And some of them are really good. And I have upheld jurisdictional. Let me say I'm not against it, but things like raising a new argument of payment claim, there's actually case law that says you can do that anyway.
It's on my notes, the Alaska Construction versus Lahat and Lovitch Floors. So it sort of opened up.
There's a Carillion case from the UK which said you can raise you can think up a new defence in your adjudication response, and that's okay.
Well,
I think
the best example
okay.
of how something completely new comes up, and no one really questions this. You've got an extension of time claim. The contractors put it in, whatever. When it gets to adjudication, there's Billy was expert in support of it, and often in a completely different analysis.
Absolutely.
But no one actually says, no, you can't bring that because you're running a different
Yeah, and
argument.
I think
Yeah,
you can.
but
bring
there
Yeah,
are
that's what I'm
but there must still be some, I guess, jurisdictional points that have the sort of the rigor in terms of a proper time bar in a contract in terms of bringing claims, or probably not to adjudication.
Yeah, I had a.
But the sort of the engineer's decision gateway and things like that, or potentially an international arbitration where you've got one party who's not a New Zealand company, and you've got an argument there that adjudication isn't the appropriate forum. And so it's, yeah, sort of I guess my question was just how often do we see it, whether it's something that ought to be tried to dispose of, because it can, as Tom says, I think sort of potentially in those rare cases, and I accept, I think, Mary, that there's rare cases, short circuit it.
What the industry would say. The industry's approach would be one of, okay, so they haven't put that argument before, but what's the answer? What's your answer? We've got time to do it.
Yeah.
People expect pragmatism. I think that, they expect, because the process in the construction sector is somewhat chaotic at a project level. And so you don't expect perfection. I think the system is kind of, designed to be flexible enough to deal with the reality in the industry. But I will say that as a respondent, the beauty is in the eye of which role you're wearing at the time. And if you're a respondent, you might really want some higher levels of procedural discipline, but ultimately I think the system is really evolved rightly to be fairly flexible and pragmatic with those kind of things.
Okay.
You just need to become a claimant more often.
We do a bit of both.
Do feel free, audience, to sing out if you've got questions. As I said, we're completely open to your questions. Otherwise, I'll keep going. I did have a sort of, it's more of a minor point, and we might just say in the panel, it's not that important to discuss, but consolidation of adjudication proceedings, and where there are multiple disputes on projects, and there's a serial adjudications being taken. How often do we see it? How worthwhile is it to ensure that they're consolidated into one? Do it as a client? Do you want that as a lawyer? Do you not want it as an adjudicator? What's your feeling?
Also, as claimant, my experience is that this is something, again, I would change about the Act. I would give this power to the adjudicator to do this as a matter of discretion, because it's very annoying if you've got two kind of related claims that somehow end up running in parallel, or you've got a counterclaim but it can't be brought, so you end up with two parallel adjudications on basically the same subject matter, which doesn't happen that often, but in the big ones it can happen, and it gets very messy, particularly if they've got overlapping subject matter and you can't agree to consolidate. So I think that is an area where, I wish it wasn't about consent for the parties, and I wish it was more about arbitrated, adjudicated discretion.
Yeah, it's almost like those sections could potentially be at odds, and the adjudicator's broad powers to manage the process as they see fit, but the parties have this right to agree to the consult, or have to agree before the adjudicator can order it be so. Sorry, I think Marion.
Yeah, I mean, the one of the ways where that arises is very much the default adjudication. And if you're on your toes, you immediately commence a merits one and run it in parallel. And then then when one of the parties says, no, we're not going to agree for them to be consolidated, the adjudicator has to produce two separate decisions.
Might be a different adjudicator though.
Well, could be, but normally you get the same one if you're on track, because you'll get your merits one up and running before the appointment, possibly.
Hopefully, yeah, we've ended up in some messy scenarios like that.
Really?
Okay, it's in terms of content, we talked a little bit about the 80-20 and the rough and ready, so I won't dwell on that. But another sort of content question is around this this extension of the submissions and evidence process that we've had since 2015, amendments to the CCA, so that now there's an automatic right of reply, the claimant to the response, and a adjudicator's discretion, right to rejoinder following the reply, which in most cases that I'm aware of, and I think in all cases I've been involved in, has been granted without sort of much consideration. Not I shouldn't say without much consideration, but granted in the sense that there should be a sort of a right to natural justice response to the reply, I think is generally the feeling. But we know, I think, in this room that the intent is that only the matters that are raised in the reply or in the response or the reply respectively are the matters that should be the subject to reply and rejoinder, and not an opportunity to open up new matters, new issues, new evidence, and split your case and bring up new things. But it does happen, I would say, in some occasions. And I guess the question I had for the panel is, how do you deal with it, and what do you see as sort of an appropriate response or consequence if a party fails to adhere to the procedural rules in that respect? Who wants to go
I'll
first?
start. Sometimes it's not till you get to the reply and the rejoinder that actually people have kind of worked out what the real argument is. So the reply and the rejoinder are often the best documents to have. One, they're brief compared to the claim and the response. But two, they've sort of they've narrowed the issues. They've worked out what the real key guts of this whole dispute's about and what they want determined. And so, introducing new things, okay, does happen, but again, it can be in that context of here's another argument, or here's an argument to your argument, or whatever. But I don't think that happens very much. I think there's actually pretty good reply. The practice of reply and rejoinder, I think, is pretty good. I look forward to receiving.
I agree. I think the reply and the rejoinder are really powerful documents, and they really are, as in terms of your arguments or in terms of the adjudicator understanding what this case is really about. They are really, really powerful and should not be overlooked as to how powerful they really are. I think rejoinder and replies are almost standard now. I don't even know that people too much worry about applying for it, or where they do, I think adjudicators always grant it, because at that stage they don't necessarily know too much about the case to know whether there should be a rejoinder or not.
So is that just a matter of sort of procedure, natural justice, right? Desire to have the evidence and the key issues and have it all in front of you, overriding sort of the procedural, what you'd face in a high court if you were claimant and you didn't put your case in and there was a cross-examination response and you then got another bite at the cherry to put in reply. I mean, is that the feeling, is that it's better that all of it's in and there's not any filtering out because this is a new matter, new issue raised?
I mean, it mitigates the regret risk, essentially, of having missed something, which, everybody knows that 95% of these kind of adjudication decisions don't go on to something else. And I think the reason for that is partly because you get every opportunity to put your case or to respond. And I think that's the power of those documents, is that it gives you ability to go, we've put our case forward. And so if you put your case forward and you feel like you've said your piece, even if you don't like the decision, you most of the time you're probably going to live with it. And I think without those steps, there's a much higher risk that people would feel like their case hadn't been put forward fully.
Importantly, a lot of people conceive things in the reply and rejoinder too. They've actually thought it through, talked it over with their client, and go, oh yeah, okay, that was that wasn't a very good argument. So that's actually really useful for my part. I find the reply and rejoinder is much more helpful to me than the claim and the response.
I wasn't saying we don't have reply and rejoinder, just to be clear. I was just saying that when they go beyond the scope of a reply or rejoinder to the reply, and when they go into brand new issues that hadn't been raised previously, do we just permit it by way? I mean, it's the Act that says, that the adjudicator has the discretion to ignore the new issues and new matters raised, which are not strictly in reply or in.
Well, if it was sticking right out there, I'd probably say something. But if it has some connection to the dispute, which it usually does, I don't find it too bad. My main thing, and I said it before, is the reply and rejoinder are short. People stop summarising the other party's arguments. They stop giving experts like 3 pages of their CV at the start of their expert thing. They stop doing that. They just put in these short things saying, this is our position. And it's such a relief after all this rubbish you get in the claim and rubbish you get in the response. It takes you 10 pages to get past what I've done in my career. It's like, So that's where I find refreshing about the reply and withdrawal.
There definitely is, I would say, a much more, shall we say, permissive attitude to evidence, rules of evidence in adjudication than in arbitration or court.
Absolutely.
I think that's an objective truth.
Oh, hold on a minute.
Yeah, well, but I don't know. Hang on, let me finish, Mary. But I don't say that critically in the sense that I feel like that's kind of what's on the tin with the process, and I think that's going back to that point about people expect a pragmatic approach to decision making and to have less formalism. Now, if you find yourself on the wrong side of that, because one of the things that I've seen in the past is in the context of expert opinion evidence, for example, things I've seen happen in adjudications which would never see the light of day in an arbitration or a court case. And you go, bloody hell, that's hearsay, or that's, that person's not independent. And
But have they, I suppose the key to that is, have they ultimately had an impact and had an effect, or as the adjudicator seen what it is, said this is hearsay, this should have been in the claim or the response, and it wasn't, and it probably encourages the adjudicator to dismiss it for that.
Sometimes I think.
Rather than jurisdictionally, you've overstepped the mark, just gives another reason for why they reject that argument anyway. And I suppose part of what's going on there is someone's trying that on, in a sense, because they don't have a better argument. They're trying to game the system in a way.
Yeah, and I guess it goes back to what Mary said sort of at the outset about, I would think you can hide and there's not cross-examination and there's not the strict rules of evidence, but these adjudicators are pecked for the expertise and the knowledge of this area, so that putting in hearsay is likely to be dismissed or ignored, or simply
you've got a
trying to
combination
repeat.
of the industry wanting to be able to say, we gave it our best shot, we didn't succeed, we move on, rather than take it further. And I think that evidence itself and the number of judicial reviews or whatever that occur, that's relatively rare. And it also, in the sense of adjudicators that are ending up, as Tom says, I think we've got a pretty great level and trust in the adjudicators that do these things, because it's very rare that there's an adjudicator taken to court on the basis of breach of natural justice and things like that. I think there was one in the very early days where he, at the site visit, he started talking to somebody and the other party didn't hear what was being said. But it's relatively rare, and most of the adjudicators are so experienced that those things don't really get by them.
Yeah, I think that's a perfect segue when you said site visit, just to bring me on to something we touched on, I think, earlier about the broad powers that adjudicators have under the Act, under Section 42. And there's a long list. I don't know what paragraph it runs to, but I just wonder about the panel's view about whether, there's to name a couple of them. Graeme, you said site visits, looking at the construction site, adjudicators going and having a look around, calling conferences of experts or conferences of even the parties giving evidence to test the evidence, appointment of an expert advisor. We often do see additional questions or submissions, at least I have, but those other powers don't, in my experience anyway, seem to be used all that frequently. And I'm interested in whether or not there should be greater use of those powers, whether it's just never or not often required. Mary, what are your views on that?
I'll do a site visit if somebody asks me to. You have to be really careful because, or a couple I've done, they've the people can't help themselves going, this is where they did it wrong, like right there, it's like, and so it sort of becomes an opportunity for a party to sort of bolster their case. But I mean, there's a lot of technical terms in construction, and sometimes going to the site and getting an idea of what a, I don't know, flux completer or whatever is, or some whatever that means is useful. But that also can be done with photos, and there's but yeah, I'd do site visits if I was asked to. Neither time I thought they were particularly useful at all. And in terms of conferences, I've never been asked to do a conference. I'm not, and I've not felt the need to do one either. I've asked questions of parties and asked them to respond and give the other chance signed a chance to respond, but no, I've not done conferences.
I've done conferences, not necessarily because I felt asked for them, but I think in the early days, conferences were a little bit more common, but I just think they're a nightmare and a nonsense. They're just a bloody shouting match. And it's very difficult for an adjudicator to control that process in a way that a High Court judge can. No one's going to stand up and start shouting at the High Court judge and just arguing over the top of the other opponent. So you don't get a particularly useful process, I don't think, from conferences. And I think today it's probably relatively rare that anybody even asks for a conference, let alone the adjudicator calls for them. But Tom, do you think that you would, as a client, you would like a conference? You want to see the whites of their eyes or the whites of the eye?
I think we've done it once, and it was a pain in the ass. Like, for the reasons I think you were alluding to, Mary. Like, there was so much paranoia around influence.
Yeah.
But it was actually probably more corrosive than constructive in the process.
Yeah.
And it was, I don't really think we got a lot out of it. Maybe I don't know. I'm always sympathetic towards the plight of the decision maker trying to deal with the amount of material without actually, because there's nothing like going around and sniffing around a site and seeing the physical environment if you're trying to understand an issue, in my experience. So I think it is, I think it can add colour, but whether or not the pros outweigh the cons, I don't know. I'm sceptical about that probably.
Yeah, I can see the benefit in a defects type case for a site visit, and I've thought about it and contemplated it as adjudicator, but never actually ultimately did it, because as Mary says, you can look at the photos, they should really be able to educate you. And I think the real worry is that, as Mary says, people are trying to influence you.
I think with the right controls, it could be done well, right? I think you need very clear rules around it, and I do think, yes, you can see photos and stuff, but there's nothing like eyeballing the problem on site if you're trying to understand the problem really. So it would be great to do more of that, I think.
Yeah, I mean, I've only had a conference called once in an adjudication. It was called by the adjudicator who wanted the expert witnesses to both be there on a delay claim and a programming issue that was not entirely clear based on the evidence to the adjudicator, and he had the experts both there, was able to ask the questions, and the experts were able to speak to each other. You know, actually, that you would have in caucusing in an arbitration or high court proceeding, and have potentially the experts a bit of a meeting of minds, or at least an explanation, not just what comes through on the expert report. So that did seem helpful, but it was, as I say, one-off, and hence the question sort of whether it would be something useful.
I think if you're going to have site visits, you've got to have protocols in advance.
Yeah, that wasn't site visit, that was a meeting of just, you know, the conference meeting. But yeah, I think you're right with that site visit. It seems like a minefield in terms of who says what to whom. But if you're in a meeting with lawyers and the experts who are professionals and the adjudicator, hi, I'm optimistic. Anyway, right, Graeme, you have an overhead, but I don't know where to introduce it. So do you want me to introduce it by way of talking about?
If you bring it up, I'll show. It's really a point about, I suppose, any litigation in a way, but in the context of adjudication, what it's really about is, you know, how do you persuade the mind that you're trying to persuade, rather than irritate the mind you're trying to persuade. And so what are the sort of secrets like that? And one of the secrets, I think, is, you know, hyperlinking the documents, right? So that the adjudicator doesn't have to go off and find the document that you're talking about, and you risk they can't find it. This is an example, and I can mention this because it was in the big Curao adjudication that we had a seminar on a year or so ago. And the point of it is this: the argument was all about whether the pipeline was going to be built above the road or below the road. So that was the fundamental issue in the whole case. And what we did, and this is from the determination, because what we did is, this is what we put in the submission, not so much in the evidence, right up front. There it is. The picture tells 1,000 words. The little round thing over there by the squiggly line, that's the pipe clearly being shown above the road. So how could there be any argument that that's what it was about? So it's about trying to simplify things as much as possible, make the point actually in the submission. So I would be not slow to take something like a photo and bring it into the submission, rather than leave the adjudicator to find the significance of it in the documents. And as I say, hyperlinking documents is critical. I suppose the other sort of thing you see too much of is bloody cases for Africa. You know, there's just thousands of bloody cases there, and the case is all about facts rather than about the law.
Yeah, it's one thing I wish for is page limits, actually. That would be nice.
Yeah, the page limits and pictures and hyperlinking. I think
Yeah,
I'd
and
agree with
generally
most of
speaking,
that. I'm not sure about
people-
page limits.
People put too many documents in adjudications, way too many. Every RFI, every payment claim, every, you know, CAN or whatever they are, and all those things. And honestly, you have to read everything.
Yeah.
So it just increases costs. Like, it's just a marginally relevant material put in documents.
How do you get to a joint bundle? Is that a potential?
A joint bundle's a good idea, but I'm not known. Well, maybe one time parties agreed on a joint bundle there, but then added all their own separate stuff. And so yeah, the amount of paper, well, it's not paperwork, obviously, nowadays, it's all electronic, but it's really ridiculous, the amount that is put in as paperwork, particularly by experts.
I've seen an example in an arbitration where there was a provision that said for every document you put in your bundle that was never referred to, you had to pay $1,000.
The swear jar,
But it's about, as Tom said, it's about trying to focus the thing down, because it's too. The sad thing about it in this electronic age is it's so easy to push a button and just dump everything on the adjudicator. And then when you think about it, it's like turning up with the adjudicator and say, look, there's 10 bloody files here, right? And we expect you to go through all this. And
Well, we do. And also, like, you only need one person to say one thing. You don't need 5 people to say that same thing, you know, like, and also you don't need to say, I've read everybody else's things and I agree with it. I kind of know that, you know, and you don't need to say, if I didn't respond to something, that doesn't mean I agree with it or don't agree with it. Like, I know that, you know, and you don't need to summarize the other party's case, because I read it, right, quite a lot, and I know what your case is. So it's a matter of being succinct, and the best submissions and the best statements are the ones that are short. And it's amazing how you know, some really good lawyers, not just lawyers, but people can make the submissions short, and that is and the statement short. Experts are another issue. We'll come to that, I assume, but they're like dark art, which is absolutely ridiculous. It's got out of hand. It's got out of hand in experts, particularly in time of delay. So
yeah, I mean, I think we should talk about experts a little bit. It is on one of those questions that we had.
Can I just throw some more firewood on this bonfire?
Go for it.
Not on experts. We'll do that later.
Sorry.
But
we'll burn
later.
That's what happens tomorrow night.
we're going to run out.
Go for it.
But in terms of I think a lot of these things, when you're thinking about, you know, any kind of system and how it should behave, because, you know, adjudication is just another system, is what are the incentives of the participants. And usually if something's not working, it's about incentive design. And one of the things I think when we look at adjudications is I think the incentives are wrong in this regard in terms of the amount of volume that gets created, because I think litigation lawyers are trained to be perfectionistic and to be exhaustive, and you don't want to leave any stone unturned. And so you take that mentality to the kind of 80-20 dispute process, and it does collide. And I think we do need to think a bit harder about how we incentivize that concision, the brevity that actually makes for a more efficient and generally a better case. And I'm sure there's various people in this room have heard me sermonize about simplicity and adjudication before, but I do think it's the hardest thing to get if you're a client. Because it's very easy to write a boring 80-page submission that says heaps of stuff and make sure that you say everything that you might want the adjudicator to think about. It's much harder to make the choice to write the 30-page one that actually is much more powerful and persuasive.
About 12 pages.
Not 30, 12. You heard it here. So just then on experts, since we seem to naturally have come to that point, and trying to be succinct and delay experts and cost experts, cost consultants in the room will forgive us, but the dark arts of both, cost QSing and programming, and how you make sure that the message and the evidence is actually in a form that can be capable of digestion by the adjudicator and understood and influence the mind of who you're trying to influence. So that's sort of what we've been talking about here, but in the lens of sort of an expert evidence as opposed to the submissions of counsel. How do you ensure that? What are the steps that you
It's become this dance for experts in time and delay. They start their expert reports with 10 pages of their qualifications and expertise and how successful they were and all these things. And then they go into criticising the other party's expert, right? So it starts with the response, obviously, and then in the reply expert, does the same thing. And so they argue about the method of the SCL protocol, obviously, that the other party used. Not only did they use the wrong method, they applied that method incorrectly. And it's kind of like, it's really tiresome. Like, it's so, like, in my view, my advice to lawyers would be try and come to your conclusion or what you think happened using the party's SCL method that they used. And then you can add your own one if you want, but it doesn't assist me. It's just so tiresome for people to go, oh, and they did it wrong. It's like standard practice now. That's what experts in time and delay do. And I think that it's not helping the industry. I don't think it's helping clients. I don't think it's helping lawyers, and it's not persuasive quite often. It's really not persuasive. And you've got to go through these pages and pages. I had 70 pages of an expert criticising the other party's method of the SCL protocol. And those methods they're not the only methods of delay analysis. That in the States they use different methods of delay analysis. So somehow it's become this Bible of you're either a Catholic or a Presbyterian or a Mormon or something, and somehow you're going to push your view through. And I do recognise that some methods are more appropriate than other methods, but I reckon you could pretty much come up with a more convincing argument to me if you applied their method and came up with an answer.
Yes. Even better than that, here's a controversial idea. Why don't you write in the contract what the delay methodology is? Because now I'm sure a lot of people that feel some dread.
It's not enforceable in adjudication, isn't it?
The same way, in the same way that you say for an extension of time to be capable of being granted, it must be on the critical part.
So that's
you just take it a step further.
But because it is such an abstract debate, often the methodology
it is an abstract debate, and you're just paying experts thousands and thousands and thousands of dollars to wank on about their own expert process. Yeah. And honestly, it is not helpful.
And
I don't find it helpful.
There's the recent decision in New South Wales. I think it's Hammershaw, the judge there, and he had the same thing. All these two experts competing. In the end, threw it all out and said, "Look, it's just common sense."
It generally does come down to that. It generally does come down to common sense, and you're trying to hide it with this method.
Yeah. I don't know. I wouldn't be that like. I think there are often very good principal arguments for why one makes more sense in the context of another, right? So there's a reason why we have all these methodologies, and there's a heritage to all of them. But I think the problem is arguing it on every case, every time, is just highly inefficient, and you do end up with screeds of nonsense that's largely indecipherable. And I do wonder if, even though there's downsides to it, I do wonder if there's a kind of prescription solution to that.
Yeah, well, one of the reasons why an expert will be cautious about bagging the other expert is they then got to stand in front of a judge and carry on, or an arbitrator and carry on like that. That's the downside of adjudication. It's all on the papers, but you do get, not just in the delay area, you get experts bagging the other expert, really than just focusing on the issue.
And then lawyers pile in and bag the experts, and it's like, it's ridiculous. Like, be nice, like try and cooperate. You're actually trying to help us as adjudicators.
But
You're
if
not trying to fight each other in this process. You're trying to help us. Your duty is to
Yeah.
us.
Yeah.
Well,
Not to the
that's fundamentally the case of.
Tom, you want your lawyer to be nice to the other.
Well, no. What I was going to say is, but if you've gone and spent your money on some amazing expert who's got all these credentials, and your counterparty puts up, somebody who came out of the swamp last week, you kind of want that credibility to find currency in the dispute. And I think one of the challenges we've had in the past is that I think often in a trial, I think credibility often presents a lot in oral evidence, but on the papers, less so. And I see a lot more what I would consider to be kind of false equivalence in credibility with expert evidence and adjudication than what I see in more formal kind of, fora.
Yeah.
So many of the adjudicators would probably know who's capable and who's not.
No, absolutely. No. But
I think strong views on the panel about expert evidence and some of the do's and don'ts and recommendations. I think we might have to start with this tomorrow, but in the interest of time, I'm going to go one last question, one opportunity for the panel. I'm going to give you a Christmas wish list. Anything you could change about the adjudication process or about the legislation itself, the CCA, Santa's come early, what would it be, Tom?
So the thing that worries me is the lack of case law in our field. Like there's a real, common law is meant to develop through case law, and we really don't have hardly any of it because everybody arbitrates and everybody adjudicates. And so there's all this IP that just gets lost. And one thing I'd love to see, there's a conversation going on in the UK at the moment about trying to disclose redacted versions of adjudication decisions. And I think they're talking about doing a pilot at the moment. And I think we should really consider that because there's a real anemic kind of problem with the development of common law and construction. So every time there's a case, it's like big news. But so that's one problem. The only two others I'll mention. I do think the Act probably needs to evolve a little bit to reflect the reality of what adjudication is used for now. Originally, as in the 5-day thing I mentioned before, it was originally conceived as a way of dealing with quick payment claim disputes, but it's become essentially kind of 4/5 of arbitration in many ways, and the primary means through which most of our disputes are resolved. But I think the Act, I don't think it's moved enough yet to reflect that reality in a few areas. But there's a whole nother layer of that, but that's my headline point. And finally, as I said before, I think of adjudication as part of essentially a system. And I think there are ways we could optimize the system through, in terms of how it performs through measuring through basically data capture. So, how the time it's taking, the cost involved, all this kind of stuff. It would be great if we could have data on that to see how the system is behaving and how we might optimize it. Because that's how you make good policy decisions, is with data. So if there was a way we could get the data, that would be useful.
I think that one of the things that I would love to see solved, but I don't know whether it's an amendment to the Act, but it's the process. There's nothing more frustrating than getting a successful adjudication, getting a charging order. Those of you that are long enough in the tooth to know about the Wages Protection and Contractors Liens Act, boy, was that a weapon for a contractor. And so a charging order is the same thing. You go through this fast track process and you spend all this money, and then it gets lodged in the district court. You'd be lucky if you bloody anybody in the office down there will find the file, let alone give you a hearing within 3 months. That's just crazy, So all this money goes down the toilet because you can't then go and get the process to implement the very piece of weaponry you were after in the first place. Secondly, I agree with Tom. I think that somehow we need to find a way for the case law to become available. If you judicially review something, it puts the determination in the High Court, and it should be, at that stage, be completely open. We did one where we got 13.5 million on a default because the engineer failed to get the certificate or the process, the document from the quantity surveyor that his certificate was relying on. So you couldn't, there was no adequate reasons in the payment schedule, right? That went into the High Court. That's a great decision, which would really complement the spotless decision. So all we know about at the moment is the spotless decision, and it's a bit iffy-waffy about when it's a valid schedule and when it's not. But that decision, it's a great decision, and there must be many others out there that would be great for the industry to be able to, as you say, redact it or some method to know. Actually, look what if that is something that will get us somewhere or won't get us somewhere.
Yeah.
I think there's dangers in the publication of decisions. People will start treating it as it has some sort of precedent value, and it shouldn't. And even in the UK, it won't have precedent value, even if they have this pilot. So I think there'll be a lot more scrutiny of adjudicators, and maybe that's a good thing. But as you say, it's an 80-20 decision. So are they going to start saying, well, they were wrong on this and right on that, and all the rest of it? So I think there's that. I think the privacy and confidentiality aspects are really important, as they are in arbitration. Those decisions aren't out there and people cope, I think there's ways of doing research on adjudication determinations that say this is what's been held, or this is the arguments that were put forward, without having the decision released like that. So I agree with Graeme on enforcement. I think that's a very clunky part of the Act. But apart from that, I love adjudication. It's great. I think it's the best thing that's happened in the construction industry since I was, acting for clients and adjudications right through to today, where I'm primarily acting as adjudicator. I think it's a fantastic system. In that same UK study, they said that there's been 48,000 adjudications in the UK. And since the Act came in 1999, since 1923, there's been about 18,000 arbitrations. So it's taken over the method of dispute resolution, and it's increasing every year. So I think I love it.
So, thank you, all panelists. It sounds like your Christmas has come already because adjudication is perfect, but we've got lots to talk about. There is one question in the audience, one person's hand up anyway. We are getting really close to 7:30, so I might take the one
They're
question.
only going to miss out on drinks.
Yeah, well, what I was going to say is this. We take the one question of the person I've seen a hand come up, and then we wrap up, and then you can accost the three of the panelists for drinks. Are we all staying for drinks? Mm-hmm. And that way we can have questions while we mingle, as opposed to everybody still sitting. Is that all right? Gentlemen, slide off the chair.
Tom, maybe the Act does need to modify for the way it's being used now, but I don't think your reason for that was right. In 2002, they wrote the Act, one section on payments, one on adjudication, nice dividing line. And it was very obvious when you read the Act, adjudication was for anything. It was obviously there for the one big thing that was inserted. So the question for all of you in response to that context of why you need to change the Act, and in fact your rationale. At the time, 22 years we've had it, how many of these adjudications we've done would have been arbitration otherwise? And how many of them would never have seen the light of day because the power imbalance would have forced poor old contract or subcontractor to suck it up?
Yeah, well, I would speculate a lot would have ended up. A lot wouldn't have ended up in arbitration, because I think and the transaction costs of arbitration have increased in that time materially as well. So. It's a big call. It's a much bigger call to arbitrate than it is to adjudicate. I think that's the great success of it all around the common law, is that, and it's a rare area of success, I would say, in the context of litigation generally, is that it has given people a relatively affordable way of getting a dispute resolved. So I think to answer the final bit of your question, I think it's been very successful in that regard. One can only speculate the counterfactual of the last 25 years, but my experience is that a lot of stuff would have just been resolved suboptimally, absent the opportunity of adjudication.
Okay, I think we're gonna.
I got one comment because
Okay.
Matthew said he was a QS.
30 seconds, 30 seconds. Go.
So that's reminded me of my last Christmas wish, which is if only after 22 years, quantity surveyors realised they had to do a payment schedule on time.
Maybe we in.
I've got my final Christmas wish, more women in adjudication and more women construction lawyers. So
Yeah, here.
diversity is a big issue, not just women, but it is a big issue.
Yeah, here. Okay, I think on that note, Nassim Vimal is going to come up and do closing before bars open in a minute.
Yeah, thank you guys. Final session. Thank you for sharing your time. Realize we've got one gone and 2 more to go. It's a lot of personal time these guys give up, so we really appreciate it. You know, without people like you deciding on the functions, thanks for sharing your knowledge with us. We've got a digital voucher and appreciation that you get. So please join me in the head of the
What's a digital voucher?
So, since it was, thank you very much for hosting. Again, without firms like this providing facilities, especially the streaming service, society wouldn't be able to, do what we do. So thank you again. As we said here, this is our last event of the year for society, so please do stick around. There's some drinks and food and some networking opportunities. And if you don't stick around, I wish you all the very best for your Christmas break. Next year we've got a pretty good lineup of events, including some interesting speakers. So we look forward to hosting you next year as well. Have a good evening.